name is Ryan Chenevert, and I represent the appellee, Ms. Peggy Plummer, in this matter. Your Honors, this case is about an insurance company who made a mistake, and they broke the rules. And now they would like to impute this mistake on my client, who followed the rules. Your Honors, there are two issues before the court. First, whether the trial court committed manifest error when it ruled that the flood exclusion was an affirmative defense. And secondly, whether pleading in extenso satisfies the specific pleading requirement of affirmative defenses. Now, addressing the first issue, the trial court did not commit manifest error when it ruled that the flood exclusion was an affirmative defense and precluded assured from raising the exclusion at trial. For two reasons. First, the flood exclusion raised new matter, which was not in assured's answer. And second, assured's attempt to first raise the flood exclusion at the pretrial conference broke the rules and was not sufficient. The Louisiana Code of Civil Procedure, Article 1005, provides an illustrative list of affirmative defenses, which according to Article 1003 must be set forth in the defendant's answer. Jurisprudence defines affirmative defenses as new matter, which must be raised in the defendant's answer, and assuming the allegations in the plaintiff's petition to be true, would constitute as a defense to the action and defeat the plaintiff's claim on its merits. And there is well-established jurisprudence that has established that a reliance upon a policy exclusion in an insurance contract is an affirmative defense.
But, Counselor, didn't your client raise the exclusion when she attached to a petition a document that specifically listed that exclusion?
No, Your Honor. We disagree, and we say that the document that was attached in the petition states in bolded 20-point font under important notice, as Your Honor pointed out earlier, that this is not part of your policy and is not a substitute for your policy. It is for your general information only and should not be relied upon to discover any type of loss of coverage.
But you're kind of saying I can use it, but they can't, right? I mean, you attached it to prove coverage, and now you're saying they can't use it to prove an exclusion.
We're saying that there's actually kind of separate documents that were all attached as one. This is a cover page to a statutory mandate by the government that required assured to send this document to every single policyholder that it has. Thus, it was not specific to my client. But also attached to this document was a disclosure summary, which entailed the renewal policy of the specific year that this claim occurred. So we submit that a document that states that it has zero legal merit is in and of itself sufficient to negate any notice that assured would like to impute on my client affirmative defenses.
Aren't we kind of nitpicking? I mean, here you attach, I understand that it's not the policy, but you had knowledge that there was an exclusion in that policy from the documents that you attached.
Your Honor, we submit that... Which
you're not arguing that that's part of the petition, right? I mean, you're
admitting
that
we're not disputing that the document is part of the petition. No, that is clear. What we're stating is that the language that contains a flood exclusion that's in the document in the petition claims that it has no legal merit on the document at all. And we submit that the plaintiff and share specifically stated that that they had knowledge of the exclusion, whereas this was just an attachment to show that there was a renewal of the insurance policy. So finally, Your Honors, the last reason under Issue 1 is in regard to the standard of review, which is manifest error. And in order for the trial court to have committed manifest error, this court must decide that its ruling was clearly unreasonable and manifestly erroneous. And in evaluating the facts to the to the rules governing pleadings in the Louisiana Code of Civil Procedure and the jurisprudence that establishes that a reliance upon a policy exclusion is an affirmative defense, and the distinguishing facts to the exception and share would indicate that the trial court did not commit manifest error. Now, Your Honors, moving to the second issue, Assured broke the rules by pleading the policy and its exclusions in extenso because it did not satisfy the specific pleading requirements of affirmative defenses.
Isn't this kind of like the Brantley case?
No, Your Honor. The Brantley case, actually, the State Farm pled, I'll read it out, they asserted all defenses under the policy included failure to cooperate, fraud, abandonment of the property, and no inhabitation for 30 days before fire. The State Farm's answer was essentially a hybrid of an in extenso and a specific pleading, where it pled all of the exclusions, but yet it actually specifically pled the defenses that it intended to use at trial. Whereas in this case, Assured, all it did was plead the policy and its exclusions. And it's clear that pleading an entire policy with the expectation that a plaintiff will receive proper notice of the one exception that, or the one exclusion that you intend to use at trial is burdensome, it's insufficient, and it's inadequate.
Is the LeVay versus Kelly and Sons case applicable?
No, Your Honors. LeVay actually does not talk about policy exclusions or as affirmative defenses. It actually refers to policy limitations, which is not addressed in the facts of this case. All it's talking about is the amount of coverage. LeVay is talking about the amount of coverage that would be allowed. It's like a cap on the policy. Whereas in this case, the defendant would actually defeat my client's claim with the exclusion.
I mean, you had 2 months to get ready, right? You had noticed that there was language like that in the policy from the petition. You then received notice in the pretrial order, again, that they're actually smart enough to claim this exclusion. You then had 2 months, right, to get ready for them to be using this defensive trial? Isn't that ample time?
Well, Your Honors, the record doesn't indicate exactly when the discovery cutoff point was, but we can assume that it would be before the pretrial conference, as the pretrial conference is to set the stage for a trial. So this would inhibit my client from making any types of discovery that relates to the defense of the exclusion, of the flood exclusion. Now, the general rule of law governing in extenso pleading was in Dixie v. Petrie, which states that the specific exclusion, such as a flood exclusion, is not raised as an affirmative defense when an insurer uses a generic pleading of in extenso. So, Your Honors, if there are no further questions, I'll move to my conclusion.
No further questions.
The truth is, Assured never raised the flood exclusion as a defense either in the initial denial of my client's claim or at any time prior to the pretrial conference. Quite simply, Assured broke the rules. Now, the record clearly indicates that Assured had multiple opportunities to raise the defense, yet it repeatedly failed to ever mention the flood exclusion as a defense that it was going to use at trial. Now, this is even more evident in the pleading of Assured's answer, which specifically raised several defenses that it was going to use at trial, yet it failed to mention the sole policy exclusion that now attempts to defeat my client's claim. Assured's attempt to raise the flood exclusion at the pretrial conference after my client had exhausted significant time.
But now, I do have another question, because essentially what you're saying is because they didn't raise it timely enough, now your client's going to have coverage that she didn't bargain for. Isn't this unjust enrichment?
Your Honors, we submit that the rules governing pleadings are there for a reason. It is to establish efficiency in the justice system and to obviously establish justice. The issue of whether or not coverage would have been allowed under this flood exclusion is not an issue in this review. What is at issue is whether or not in extenso pleading is sufficient, and we submit that it is not. Now, the pleading at the pretrial conference was grossly untimely and was properly precluded by the defendant, by the trial court. In addition, this court, by allowing an insurance company to rely on a nonspecific and vague pleading that somewhere in its entire policy a defendant defense might exist would surely open the proverbial door to inadequate pleading and insufficient litigation. This will inherently lead to a sacrifice of the integrity of this state's justice system. It is for these qualifying reasons, Your Honor, that we respectfully request that you affirm the trial court's ruling. Thank you.